That's what I'm saying. Good, very good. Good. I think all the panelists are here now.
I think we are waiting for Mamta man. Sir.
Is there?
I am there. I can see everyone.
Oh, great. We can see you too, ma'am.
You can see?
Yes, ma'am. Yes.
We crossed 100.
119.
Yeah.
Thankfully, we took that 100 plus back.
We are going very fast than the IPL scores also now.
It's increasing very fast because the time is yet to be over.
Yeah.
It's already 10:58. 11 is yet to be there.
Abizar. Where is he?
He's coming back on his chair with a tea.
For a moment, I thought his chair is looking like a fast track car.
No, Baba. Normal office ka chair. I just got to get a cup of tea for me. Sorry.
Prakul, we are all praises for your for the PPT deck that you've prepared.
Ma'am, thank you so much, ma'am.
Come out exceedingly well.
Prakul, it all depends on how you present now, huh, boss?
Yes, ma'am. Yes,
Like the slides, but you have to present well.
Prakul also has a podcast, ma'am.
Hmm.
Virtual Law is baby. He also started a podcast while he was at GIP. Insolvency podcast.
That's wonderful.
Okay.
Yes,
And I
ma'am.
hope you're still continuing with it.
Yes, ma'am. Thank you.
150 crossed.
150 crores.
Everybody is putting in their name and registration number. Are you also giving them some creditors?
We have not asked, ma'am, yet. So I requested IBBI to share the invite with all the IPs because I thought there'll be a lot of use for them.
Yeah,
So
It is interesting to see 150 people without a CP.
That's true, sir.
Since
That's
everybody
true.
is mentioning they're expecting the CP hours for this. The messages going from IBBI, they might be thinking that the CP hours will also be available.
So I think ISCA now can give or for trainings. We'll have to just find out if this can be accommodated.
Navandar is also part of the panelist.
Who?
Mr. Praveen
Navandar. Navandar sir is not here, no?
He has joined, but he is there in the members.
Yeah.
So
Prabhu,
he
can
is
we bring him
requested.
here?
Yeah, but
Sure.
he needs to do the
Thanking.
vote of thanks. Yeah.
Yeah.
We'll
He
do
needs to
that.
deliver the vote of thanks. And
Past 175 now.
The live streaming is also on, sir. It's streaming live on YouTube. I'll tell you what's happening there.
So Navandar is there now.
Yes.
so another 2 minutes should we begin? Prakul, what do you suggest?
Yeah, we can.
Yes, ma'am.
2-3 minutes.
Yeah.
Yeah, 2-3 minutes we can wait because it's just 11:01.
Let us cross the 200.
But let's, if our time is up, let's start. Huh? It was 11 o'clock. Dr.
So let's
Henry.
start.
Let's start.
Yeah, sure.
People will keep joining.
So good morning, everyone. Thank you for joining this webinar on IBC Ordinance and Prepack regulations. I would like to begin with introducing IICA. Indian Institute of Corporate Affairs works as a think tank to the Ministry of Corporate Affairs. Center for Insolvency and Bankruptcy serves as an APEX school of learning on insolvency and related areas in association with key stakeholders and institutions. Center has conducted various webinars on topical issues in the field of insolvency. It had given several inputs to the Ministry of Corporate Affairs on insolvency and restructuring. I'm happy to share with all of you that policy inputs given to MCA on the subcommittee report of Prepacks, one of the suggestions were put into consideration, which is on giving more autonomy to resolution professionals. Another suggestion on voting was also relooked into by the ministry. Center offers a program called the Graduate Insolvency Program, which is the flagship program to create young cadre of insolvency professionals. In short, I can say that IICA is a breeding ground for great minds, and the graduates of GIP have been raising our flags high. It is also my honor to share with you that Shri Abhishek Devanji, who's present among us today, he is the course director, honorary course director for the program, and with help of esteemed advisory board members and academic council members, and also all the industry leaders, the program has been gaining success. The purpose of today's discussion is to get practical insights of IPs who deal with MSMEs. It is my pleasure and honor to introduce the esteemed panelists to all of you. To begin with, let me introduce Shri Mamta Binani ma'am. Ma'am is past national president of ICSI and India's first insolvency professional and resolution professional of Synergy Dure Automotive Limited, the first case to have seen a resolution in IBC. It's my honor to share with you that ma'am has been awarded with Insolvency Expert Award for 2020. Ma'am is also an academic council member for the GIP, and we have been growing and working under her leadership. Shri Abhishek Devanji, sir needs no introduction, but let me share with you that he wears many hats. Sir is EY India Financial Services leader. He's also been members of government or regulator committees to help implement the change in the area of IBC and restructuring. Sir is experienced financial services and restructuring advisor who holds 26 years of experience in financial services industries. He has executed and advised over hundreds of transactions, worked on government projects, and is a member of various committees formed by the government or regulator. We also have with us Shri B.S. Rathi ji, who is a rank holder, chartered accountant, and master in business and finance. Rathi sir has passed insolvency exam in the first few days of the launch, but didn't take degree as he is a whole-time member of Sumedha Fiscal, a listed company. Sir has taken many sessions on IBC practice for WIRC. Sir is also director of IPE named Sumedha Management Solution Private Limited. We also have with us CA Snehal Arvind Kamdarji. Sir is partner of MS Jain Jagwat Kamdar and Company. He has been part of around 30 plus transactions of IBC in various capacities and handled MSME companies under CIRP in liquidation. He is associated with SME segment with Associated Merchant Bank and have been instrumental in bringing more than 20 SME IPO. Sir has syndicated debt of more than 5,000 crores in last decade. He is part of research committee of ICAI IPA. Shri Yogesh Gupta sir is founder of Yogesh Gupta and Associates. Gupta sir is a company secretary and co-founder of IURIS Consultants LLP and EA Consultants LLP and corporate and IPR law professionals. Shri Yogesh Gupta sir has authored various articles on topics of IBC, corporate laws, corporate disputes, securities, and IPR. It's also my pleasure to inform you that we have with us one of our very bright students, Shri Prakul Thadi. Prakul is the first student of first batch of GIP who interned with EY for his long stint, right now interning with NCLT. Prakul also has as a startup called Virtual Law, as you see on the screen. At GIP, we also help students incubate their ideas and come up with their own startups. That is our way of making IPs Atmanirbhar. And Prakul has started this Virtual Law. He will be starting giving a presentation on the ordinance and the regulations. Let me apprise the participants that the purpose of this discussion today is to get practical insights of IPs who are working in the MSME sector and find the gaps which could be addressed to the discussion. And I assure you that all the discussion that arises from this platform will be given and taken to the right stakeholders to ensure that we all together work towards a very strong insolvency regime. Just to share with you some ground rules, you can put your questions in the chat box here, and we will take your questions as we move along. We could also park some questions towards the end. The flow of the event would be that Prakul would first give a brief presentation on the ordinance and the regulation, after which the floor will be handed over to Honorable Abhijay Diwanji sir, who is also the moderator for these sessions, and he will do the tough job of asking tough questions from our esteemed panelists. And through this discussion, we'll try to get best of what is there in the Prepack regulations and also identify what needs to be addressed and given a due consideration. And without much ado, I hand over the floor to Prakul. Prakul, over to you, please.
Yeah, Dr. Nidhi, just a few housekeeping points. We'd like everybody to go off video and off audio, please, so that there is no disturbance in the flow of the presentations. If there are any questions of the presentation or of the panel, could you please put it down in the chat box or the Q&A box so that we can address it? We have budgeted a good 15 to 20 minute Q&A post the panel. So we will take it up there, and obviously we'll also then unmute the mics for people to ask questions. But we'd appreciate that the next half an hour, 45 minutes, 50 minutes that we have, can we please have it uninterrupted? Thank you very much.
Sure, sir. Thank you, sir. Now over to you, Prakul.
Yes, ma'am. Thank you so much. Thank you so much, sir, for setting the ground rules right. So as Dr. Neeti had rightly pointed out, the very intention behind making this presentation is to give an idea of what has been brought forward in the ordinance and what did the regulations say. So we have also included the provisions with respect to the regulations, and we have also made sure that those provisions which have been retained from CIRP are not being repeated. So that, we just want to highlight as to what went in this process of coming out with a framework on PPRP. So this presentation will not answer the questions why or how. It will only give you an understanding of what has been provided in the ordinance and the rules and the regulations. Post this, the panelists will deliberate on this, and after that, your Q&A will be open. So without much delay, let us start this presentation. So as we all know, the Prepacks has been introduced exclusively for the MSMEs, and hence, there is no other criteria over there that this this ordinance of the IBC has been brought purely for the sake of resolving the stress of MSMEs. So what are we going to cover in our presentation? So we have 10 major headers to be covered during our presentation. So I'll take you through one by one in a very exclusive manner, where we will focus on the intricacies, at the same time understand as to how the PPRP provisions have been provided both in the code, the ordinance, as well as in the regulations. Foremost, there have been 5 definitions introduced in the code, in the ordinance, in the code by way of the ordinance. So firstly, the preliminary information memorandum. So we will be discussing this anyways in the subsequent slide, but still, this is particularly information which is provided by the corporate debtor to the resolution professionals in order to make sure that the resolution professional can make an information memorandum. So preliminary information memorandum will already be in place. Within 2 days from the insolvency commencement, this information memorandum, this preliminary information memorandum shall be provided to the corporate debtor, by the corporate debtor to the resolution professional. Then the insolvency commencement date is, again, they have made sure that it is on par with the CIRP. So the date of admission of the application will be deemed to be the insolvency commencement date in respect of the Prepack as well. Then coming to the Prepack period. So in our CIRP, if you would have seen it, it defines the period as 180 days. However, thankfully here the definition clearly says that it begins from the commencement date and it ends as and when the adjudicating authority passes an order. Even though in CIRP the effect is the same, but in the definition they have clarified that there is no time period to say. So it will end as in the PPRP. You ask me, like, what is it that Prepack has introduced? Prepack has introduced a base resolution plan. So Prepacks are associated with base resolution plans. So as you can see that Prepack, the word itself signifies that there is something which is already in place, which is coming out in the process. So that's something which is already in place. The base resolution plan will be provided by the corporate debtor, and it will be ready even before the prepack is initiated. So we will see all of it in the upcoming slides. And then we have a definition on PPRP costs as well. So this is similar and parallel to what the IRP costs are there. But I would like to get your focus on a particular point, which is C. So if you see the clause C under PPRP costs, it says that the costs incurred by the RP in running the business of the CD as a going concern. So now the issue here is a prepack. The prepack insolvency resolution process has been introduced in a way that it will be a debtor in possession model. So when there is a debtor in possession model, how does this question that RP running the business of corporate debtor arise? Because the code clearly states and sets out that the role of the RP is only to conduct the PPRP process. So where the role is limited to conduct of the process, how do we even include it in the PPRP costs? Right. So keep this question in mind. We will be addressing it in the subsequent slide, and it has two other dots to be connected. We will get back on this because this is very critical in the PPRP process. And apart from that, one important note is that even the fee. So an IP, unlike your CIRP, in case of a prepack, the role of an insolvency professional begins even before the initiation of PPRP. So the whatever are the duties which such insolvency professional exercises or such insolvency professional performs before the initiation of prepacks, all those costs, the fee of the insolvency professional and any expenses incurred shall also be considered as PPRP costs. So this is about the definitions part, but of course I understand that this has to be connected with the subsequent slides. So let us go into the main elements of the Prepack framework. So as you can see on the screen, so there are certain criteria for a prepack to be initiated. So section 54A, which is the first section, or rather under Chapter IIIA, this is the first section, section 54A. It sets out the various conditions which a corporate debtor has to meet in order to initiate a prepack insolvency resolution process.
Rakul,
now, in the prepack, yes.
Rakul, please go a little slow because it's a very new regulation and very new.
Sure, ma'am. Sure, ma'am. Sure. Yeah. Yeah. So section 54A, which is introduced in the ordinance, sets out the various conditions required for initiation of prepack. So under that, the first and the foremost condition, which we already just discussed, is with respect to the CD being classified as a MSME. So for this, the rules which have been floated by the MCA clarify that either you should produce the Udyam registration certificate or you should prove that you meet the investment criteria, the criteria which has been prescribed under section 7 subsection 1. So a CD should essentially be an MSME. Second is with respect to a past CIRP which has been undergone in this entity. Let's say, I mean, the corporate debtor has already completed its CIRP and 3 years have not yet been completed. Or there has been a past PPRP, that is prepack insolvency resolution process, and still the 3 years period is not yet done. In such a case, one cannot initiate prepackaged insolvency resolution process. So the PPRP can be initiated only after a cooling off period of 3 years from either a completed CIRP or a PPRP which has been undergone earlier. So that is one criteria. And the second criteria is where a CD is undergoing the CIRP. In such a case, sorry for the correction there, it's where a CD is undergoing CIRP, you cannot initiate a prepackaged insolvency resolution process. So it is a completely exclusively different process. So where a CIRP is pending, you cannot go and initiate the PPRP. Next in line is with respect to an entity where a liquidation order would have been passed. So it is clarified that where an entity is undergoing liquidation, now the promoter cannot come back and say that I will initiate prepacks. So that is our third condition. The fourth condition is the resolution applicant, that is the CD, in this particular case of prepacks, has to be eligible to submit a resolution plan under 29A. So, but this is again subject to the section 240A, because the ordinance under section 17, the last section of the ordinance, had also amended section 240A to make sure that it applies even for a prepack insolvency resolution process. So which means that in a prepackaged insolvency resolution process, the resolution applicant need not meet the criteria prescribed under 29A, C and H. So these are two critical elements which any resolution applicant faces in an ordinary CIRP. But thankfully, since it is an MSME, this has been excluded by way of applicability of 240A. So this we can say as a brief relief for the MSMEs. Next, coming to the fifth element. So all the 4 pointers on the right side, that is with respect to the RP, declarations, special resolutions, and the financial creditors, these are more of the procedural aspects which has to be looked into, because the first 4 are merely things which have already been done, but the next 4 are the things which have to be done. So here we'll have to keep a focus on what is the role of a RP. So even though I just kept it as RP, but the concept was that there has to be a proposal of a name of an insolvency professional even before the initiation of PARP is done. And such insolvency professional also has got certain duties to be performed, which we'll see in the subsequent slide. So now this insolvency professional, the name of such insolvency professional cannot be proposed by the CD. So that has been one clarification given in the ordinance. So a corporate debtor, even though the corporate debtor is initiating the PPRP on its own, it cannot propose the name of the IP. So who shall propose? The financial creditors. And when I say financial creditors on this slide, I imply unrelated financial creditors. So the unrelated financial creditors who are having at least 10% of the total financial debt. So they are the ones who are eligible to propose the name of an RP. And this has been clarified in Regulation 14 of the PPRP regulations brought forward by IBBI. Now, after this criteria, the next criteria is such proposal shall be approved by a financial creditor. So firstly, a proposal being made by a financial creditor, and secondly, a proposal being approved by the larger set of financial creditors, which is with 66% of voting share. But here there is a particular catch which we'll have, which is a very important element in terms of appointment of an insolvency professional. The regulations have prescribed the terms of appointment in Form P3. So, okay, rest all the terms includes the name of the RP and the details, but one major element which has been included in the terms of appointment is with respect to the fee payable to the RP. So we'll come back to that on the next slide. So for now, the concept is the IP's name has to be proposed by the financial creditors who are holding at least 10% of the total financial debt. And such proposal has to be approved by the financial creditors with 66% of their voting share. So this is with respect to the appointment of an IP even before initiation. But what does that IP do? What is it that fees which the IP gets? So we will look into it on the next slide. Next in line, that is condition number 6, is with respect to the declaration. So a declaration has to be made by the majority of the directors or the partners, which if it is the case of an LLP. And what should they declare and what is the form? So the regulation 16 of IBBI PPRP regulations stipulate the form as Form P6. So in Form P6, the following 3 declarations have to be made. Number 1, that it will be the PPIRP shall be initiated within 90 days, and this 90 days will trigger from the date of declaration. So within 90 days, I shall initiate PPIRP. That is the first declaration I will make. The second declaration I would make is with respect to the initiation not to defraud any person. So I'll have to declare that this initiation of PPRP has not been intended to defraud any person. And the third declaration is with respect to the name of the RP. So whosoever is the RP who has been proposed and approved, such name should be contained in the Form P6 so that will go to the next stage. So what is the next step? So now that the board of directors meet, they give a declaration. The next step is to obtain approval from the shareholders. This is similar even for a Section 10 application. So the same has also been adopted here. And the final condition is with respect to the approval for filing an application to initiate PPIRP. So such approval again. So now first again, initially you went to financial creditors seeking their approval for the IP. Now subsequently for the second time you go to the financial creditors seeking their approval for filing an application for initiating the PPIRP before the adjudicating authority. And such approval shall be made by the financial creditor in Form P4. And this has been stipulated in Regulation 14. However, for a financial creditor to make such an approval, or rather to approve the initiation of PPIRP, 3 important documents have to be produced before the financial creditors in their meeting. Number 1, the copy of special resolution. Number 2, the copy of the declaration which has been made by the directors or the partners as the case may be. And number 3, and the most critical and important, is the base resolution plan. So a copy of the base resolution plan should be ready at the time you are seeking approval from the financial creditors, not on the base resolution plan, but for initiation of a prepack. So this should not be confused as to the financial creditors voting on the plan. So it's merely that the financial creditors has to be provided with the plan, and subsequently the financial creditors will approve initiation of prepacks, but not the contents of the plan. So this is with respect to the financial creditors, second approval required by the financial creditors. So a quick summary, we need 2 approvals from financial creditors even before initiation. First approval will be for appointment of an insolvency professional, or rather proposing the appointment and approving such proposal. And second approval will be for initiation of PPRP process, the prepackaged insolvency resolution process. So these are the conditions prescribed under section 54A. If these conditions are met, only then a prepack insolvency resolution process can be initiated. Now, who will ensure that these conditions are met, and who will look into it? Will the adjudicating authority look into whether these conditions are met, or has that a responsibility been granted on someone? Let us look into it on a subsequent slide. So before initiation of PPRP, as we have already discussed, there has to be a general meeting. The base resolution plan has to be ready and people have to vote on it. And now let us look at the consent of the FC, where I was talking about the terms of appointment. So now the most important point which the form P4, that is the terms of appointment of an RP or as an insolvency professional proposed to be an RP, what is this? This important clause which has been highlighted is with respect to the fee payable to the RP. So the form P4 contained a table, a simple table, which clarifies, which states that the financial creditors who are approving the name of the RP, that is the 66% of the financial creditors who are approving the name of an RP, an authorized signatory of all of them has to sign this form P4, wherein they state clearly that so-and-so person has been approved to be appointed as an RP. And second, their fee payable is as under. On the left column, you will have the fee payable for the period of performing duties before initiation of PPRP. What is the amount? Second, fee payable for performing duties during the PPRP. What is the fee payable? Third, what is the fee payable if the management of affairs has been shifted to the resolution professional, which means has been vested with the resolution professional. If we go back and look at the definitions, if you remember, we were discussing in the prepackaged insolvency resolution process cost. Why is it that the cost of running the business has been included when prepacks means a debtor in possession model? So now this is the second dot which we'll have to put in mind as to whenever such management of affairs is vested with the RP, which means initially it will not be vested, but during the process there is a provision that the management of affairs may be vested with the RP. So if the management of affairs are vested with the RP, the role of the RP will become higher. The role of the RP will definitely increase for the simple reason that earlier you were conducting the process. Now, along with the process, you should also run the CD as a going concern. So these 3 different fee payable has to be agreed even before the PPRP has been initiated. So this is a big difference and a big change brought forward to protect the fee payable to the RP or to the IP. Now, what are such? Okay, so now we know that even before the PPRP, there are certain duties which the IP has for which he will be paid as well. So what are those duties? The duties are, number 1, commences. Firstly, when does this duty commence? These duties commence as and when the financial creditors approve the name of the RP. So that is again a very important element. So your approval will be the date from which the IP's role will start. I'm clarifying this, the word IP. It's not, you are not appointed as an RP, but you are an IP proposed to be appointed as an RP. Now, when you commence such, from whenever the financial creditors approve your name by passing 66% of giving 66% of voting share for your name, that is when your role starts. So what is that duty you will perform? The duty is to prepare a report. What report? The report comprises of 2 important elements. Number 1, whether all the conditions prescribed on the previous slide, right? So we have seen on the previous slide as to all the conditions, whether these all conditions have been met or not. That will be the first point I'll have to comment on. Second, whether the base resolution plan. So the base resolution plan, if you see, which has been provided to the financial creditors before even they vote on such for the approval for initiation of PPRP, whether such resolution plan is in conformity with the IBC, that is it in conformity with section 30 subsection 1 and 2. So the basic requirements of a resolution plan have remained intact. So whether they are meeting such criteria or not is also something which a insolvency professional proposed to be appointed as an RP has to look into, which means your role of looking into the plans will begin even before the base resolution plan will begin even before a PPRP has been initiated. Now, once these two are confirmed by the RP in a report, such report shall be by way of Form P8. So Regulation 17 of the IBBA regulations stipulate Form P8 to be the format for such report. So where will this report go? Am I reporting it to the adjudicating authority? Yes, it is indirectly being given there, because when the corporate debtor is filing application before the adjudicating authority, this report shall also be enclosed along with the application. So that is the criteria. Alongside this, the Regulation 15 of the PPRP regulations also give another role to the IP, duty to the IP, which happens even before Prepack has been initiated. What is that? It is ascertaining the classes of creditors. So generally we see that when in case of a CIRP, along with the public announcement, we come out with stating these are all the class of creditors and these are the 3 IPs, you'll have to choose one of them. However, in case of a PPRP, that process will trigger even before initiation. You need not wait till, or you should not wait rather, till the admission is done. Even before that, if there is a class of creditors, ascertain it, along with sitting with the CD, get the information and ascertain that there are class of creditors. Second, then you will have to give choice of the 3 insolvency professionals to such class of creditors, and within 3 days the class of creditors will approve one of them, and then you select the person who is having the higher votes will be selected by the IP, and subsequently such selection shall be informed to the applicant, so that applicant here is nothing but the corporate debtor. So that the corporate debtor, when it files an application in Form 1 of the recently announced Insolvency and Bankruptcy PPRP rules, in that particular form, even this appointment and the name have to be attached, so that the adjudicating authority shall appoint both the RP as well as the authorized representative. So this is the idea. So before initiation, these duties have to be performed by the RP, and at the same time, other aspects with respect to holding a general meeting, making sure a base resolution plan is ready and the FC's consent being obtained are critical elements which are even triggered before an initiation of PPRP. So now, when does my duty as an IP before the PPRP cease? My duty ceases when the corporate debtor fails to file the application within 90 days of such declaration. So failure of filing application, at the same time when it fails, I am also relieved of my duty. Second, where the PPRP application is either admitted or rejected. If it is admitted, I become an RP, so I step into a different shoe. That is where the second element comes, that is performing duties during CIRP. But so for this to happen, my duties before PPRP shall cease right at the time of 90 days. And then finally, if the if it is rejected, so if it is rejected, again I go back. So now there is just one pointer I would like to mention here is that if the application is admitted, then the fee of the RP and the expenses shall be considered as PPRP cost. But if it is rejected, then the CD shall bear the PPRP costs. So that is the fact, right? So now coming to application for initiation of prepacks. So when a corporate debtor who is applying for initiation of prepackaged insolvency shall make an application in Form 1. Before I proceed, somebody had put on their mic. I request, please put off your mic. Thank you. And yes, so application for initiation of prepackaged insolvency process, Section 54C stipulates the basic requirements. And as stated earlier, the rules of PPRP rules have come out with a form, which is Form 1, which has to be served even on the IBBA, even before you're filing it with the adjudicating authority. And it will be filed by the corporate applicant who is meeting all the conditions. And these are the documents. The declaration in Form P6 is nothing but declaration by the majority of directors, a copy of special resolution, approval of financial creditors to initiate a PPRP, and the proposed RP's written consent, and then consent has to be there, and then the RP's report, as we have discussed, the RP's report also has to be enclosed. Then the declaration procedure. This is another interesting element is with respect to the declaration by the CD. So a form P7 has been introduced in the IBBA regulations, which it's a format for declaration that either you have no avoidance transactions or you have the following avoidance transactions in as per your analysis. So this is a declaration which a CD has to make, and it also has to be enclosed to the application in form 1. So then the information, the books of account, in the sense the audited financial statements and the stuff will have to be there. And then name of the authorized representative, if any, this also we have discussed. And finally, the latest and updated Udyam registration certificate, or if in case you don't have, the MSME doesn't have a Udyam registration certificate, then the proof that it is being classified as an MSME, that is nothing but you should show a proof of your investments in plant and machinery or equipment, which is meeting the criteria prescribed under the MSME Development Act 2006. Right. So this is with respect to the application. Now let us just have a quick look at what adjudicating authority will do. So once an application is filed, adjudicating authority's role again is limited here to see whether the application is complete. If it is complete, yes, the green tick, the adjudicating authority will go ahead and admit the application. And along with the admission, there will be declaration of moratorium, appointment of an RP, and the public announcement is also being made, which is fine. And the commencement will be deemed to, the date of admission shall be deemed to be the commencement date, which is also fine. Now, if it is rejected, then if the application is incomplete, it can be rejected, and 7 days time is given for rectification. So this is all fine. What is the important catch in this particular provision is with respect to declaration of moratorium. Even the report of PPR, report on Prepacks, which has come before this ordinance, has clarified that, or not clarified, rather they have recommended that in case of a prepack, the moratorium should not include essential services to be mandatorily provided and not terminated. So that provision has to be eliminated. So the code, as the ordinance had recognized it, or rather the ordinance had admitted such provision, and then the ordinance has also highlighted that section 14(2) and 2A will not be operable during PPRP. So this was not stated as such in the ordinance, but ordinance says the declaration of moratorium for the purposes under 14(1) and 3. So they excluded 14(2) and 2A, right? So that's the interpretation to be made, that 14(2) and 2A with respect to provision of essential services mandatorily to the CD and non-termination of essential services and critical services will not apply. So the RP also will not have a role of identifying the critical services for the corporate debtor. And there is again an exception to this. This exception, again, I take you back to that particular dot as to why a cost of running a business as a corporate debtor, why the role of running a business as a corporate debtor comes into picture. And this is another dot which you'll have to put on, just put it in the back of your heads, that if at all the adjudicating authority orders for vesting of the management with the RP, which means if it takes this DIP model, that is debtor in possession, back to creditor in control, and or rather if it eliminates the debtor in possession, in such cases, every provision would apply, also the moratorium. So this is with respect to application, which has to be filed. And the important catch here is with respect to the moratorium. Moving forward, on the application of initiation, and a new section has been introduced, section 11A. This is purely to clarify that if there are pending applications or conflict of PPRP and CIRP, how to address it. So there would be two circumstances which would come. One is with respect to an application which is pending before adjudicating authority on prepack. So where a prepack application is already pending, that is you filed it even before a CIRP application, then the adjudicating authority shall consider yours first, pass an order, and only, first dispose of your case. That is the basic application. So my prepack application shall be firstly disposed. What is the second situation? The second situation is I didn't file, but before me, the CIRP, some other creditor of mine had filed the CIRP application, and that is pending. Then I have been given 14 days to immediately file my prepack application. If at all within 14 days I file my prepack application, then the adjudicating authority shall first dispose my application. And the relevance is that firstly, my application will be disposed. If it is disposed in the favor, in the sense, if it is admitted, then CIRP will not be triggered. PPRP will be triggered. If it is rejected, then they will look into 7, 9, 10 and decide whether that has to be admitted or not. So that is with respect to where I file within 14 days. But what if I don't file within 14 days for whatever be the practical reason? In such a case, the adjudicating authority will first dispose of the CIRP application. So this is only with respect to clarifying as to a conflict where both the applications are pending. Now, one important clarification again they've given is that if a CIRP application is pending on the date of commencement of the ordinance, right? So in such cases, there would not be any application of whatever you're seeing on the screen. It would continue as such. So any CIRP application which is pending on the date of commencement of this ordinance, this particular section will not apply. And secondly, if the CD is undergoing prepack, that is, if you're in the middle of a prepack, no financial creditor can go and file any application initiating CIRP. That is another clarification provided, not in section 11A, that has been added as a clause in section 11. Third is with respect to CIRP application. Since we are also discussing a fresh application being filed, so where a prepack has been ordered, or where suppose a CD had, or any resolution applicant had successfully been a successful resolution applicant and the prepack has been resolved, has been done, then 12 months after from the period of closing of the prepack, for a period of 12 months, the buffer period has been provided, during which time no fresh CIRP application shall be filed. So this is with respect to applications being initiated. We'll move forward on more interesting aspects. That one is with respect to the role of resolution professional. Section 54F of the ordinance, of the code had clarified what is the role of an RP. So the first, and I would insist on this particular role, is that the conduct of the prepackaged insolvency resolution process. So the RP's core role is to conduct the process. The wordings used are very clear, conduct. So we are not going into the managing the affairs of the corporate debtor. For that, look into point number 3. So our role is rather monitoring the management of affairs of the corporate debtor, but not going into the corporate debtor. In the sense, not going to manage the corporate debtor as a going concern. So we'll have to merely monitor the management of affairs. And how do we monitor? So regulation 50 of IBBA regulations has given an indication as to how it can be monitored, where you can ask the CD for certain information on a monthly basis, and where you can visit the plants, you should be permitted to inspect things like that. So that is to monitor management of affairs. So our role is very clear, that is conducting the process. Second, coming to the list of claims. So list of claims by, in case of a PPRP, there has been a paradigm shift in which the claims will be handled. Earlier, that is in case of CIRP, we invite people to, we publish a public announcement so that people will submit their claims, and all those claims are verified, and then amount is determined, and then a list of claims is maintained. Here, in case of a prepackaged insolvency resolution process, the CD has been given the responsibility or the obligation to make the list of claims, and such list of claims shall be given in form P10, and such list of claims will be submitted by the CD to the RP within 2 days from the prepackaged insolvency resolution process. And after submission of such claims in form P10, the RP shall look into the claims and confirm the list of the claims. So the list along with the details of the claims would have been provided, will be provided by the CD, and the RP has to confirm such list which is submitted by the CD. And upon confirmation, we will have to inform the creditors regarding their claims. So if there are 10 creditors in the list of claims provided with the CD and confirmed by me, to all such creditors, individual informations as to, individually I'll have to inform them that as per this is what is the claim you have, and we are going with this. And subsequently, as we all pretty well know, we'll have to keep maintaining the updated list of claims. But again, here there is one important catch in terms of the timelines. The law requires that within 7 days, you'll have to constitute a COC, which effectively means within the same 7, and again, so constitute a COC based on the confirmed claims. That is the language being used, which means I'll have to, before constituting the COC within 7 days itself, I'll have to confirm the claims as well. So it's as good as verification of claims within 7 days from the last date of submission. So since the submission is removed, so only the 7 days has been retained, and 7 days is the provision we have. However, we'll have to call the meeting also. So if 2 days within 2 days, if the claims are submitted, we will effectively end up having only 5 days within which we can constitute the COC. So the next, again, as we are going in the flow, the first, again, next role is to constitute the COC. convening and attending the meetings. And in case the responsibilities or obligations of the directors or partners, as the case may be, if they have been contravened or if there is a breach in such obligations, as an RP, if it is in my knowledge, I have an obligation to inform it to the COC. So this is with respect to this. Now coming to the public announcement, as again we have seen that in CIRP, public announcement is meant to invite claims. Firstly, to inform the public at large that we are undergoing CIRP, and secondly, inviting claims. But in this case, there is no need of a newspaper publication. You can merely upload it on the website of the corporate debtor and that of the IBBI, and you should send it to every creditor, whoever is there in your list of creditors. So the list of creditors will be in form P2. So the form, whoever are there in the form P2, the list of creditors, send them this public announcement, and rest upload it on your website and upload it on the IBBI's website. And this public announcement shall be in the form P9. So this is very clear. Is only to inform them that this is the entity which is undergoing PPRP. That's all. No invitation of claims. That has to be a clear understanding. Next comes the responsibility to prepare an IM. So as again, IM preparation of IM requires a lot of time to be spent, because a lot of details have to be informed. So what IBBA did is IBBA carried forward the same set of details which are required under CIRP. The same set of details are even required in a PPRP in your information memorandum, and such information memorandum will be prepared basis the preliminary IM which is submitted by the CD, which indirectly means the CD at the time of submission of preliminary IM shall keep it in mind that such preliminary IM will also contain the details which an IM should contain. So all the section 29 read with the regulations, all those details have to come in the preliminary IM, and based on that preliminary IM, the IP will prepare a information memorandum. Next, this information memorandum shall be submitted to every member of the COC within 14 days. So within 14 days from the admission, from the appointment, the information memorandum has to be submitted to the COC members. So that is again a critical element of compliance. Next is filing of applications for avoidance transactions. So avoidance transactions applications, again, they remain the same, but the timelines have been crunched that within 30 days you need to form an opinion, 45 days you will have to determine the amount, and within 60 days you will have to file the application with the adjudicating authority. So 30, 45, 60 are the new timelines in place of our earlier timelines. And then coming to appointment of professionals. The reason why I kept it as a role is because now there has been an insertion. As you can see on the screen, the regulation 10 states that such professional. So there are 5-6 criteria, but I felt this is something which is important to be informed, that a person who is not registered with the regulator of the profession concerned shall not be appointed. So you cannot generally appoint any person and claim him to be a professional. So such professional who claims to be a professional shall be registered with a regulator who governs such profession. So thus, this has been introduced in by way of IBBI PPRP regulations in Regulation 10. So now there are 5 more roles, 5 more aspects which we'll have to look into in terms of the role of the RP. That is, you'll have to appoint 2 registered valuers. There is no provision provided for appointment of 3rd valuer. So whatever be the difference between the 2 values, the average of it is what is the finality. There is no need of a 3rd valuer, and such appointment shall be made within 3 days of the appointment of the RP. This is dealt with in Regulation 38. And then there is another interesting concept which is evolving in the regulations is with respect to opening of a separate bank account. This we'll have to read it alongside section 54F4, because under 54F4 it clarifies that an RP cannot instruct a financial institution. Earlier in CIRP, we instruct financial institutions, but in the case of a PPRP, RP's role is limited to asking for information. So as and when the information is asked, the financial information will provide, but there are no instructions taken from the RP, which effectively means I cannot have a control over the bank account. So what the law said was, the CD shall maintain a separate bank account wherein the fee of the RP and the expenses which the RP will incur to that amount which is approved by the COC shall be maintained in that bank account, and RP will be given a power to operate such separate bank account. Right. So this is something which is unique, which is not there in a CIRP. So this is again looks like a protection for the RP fee and the expenses for conducting during the PPRP. Next comes the invitation for resolution plan. So earlier we had the concept of invitation for expression of interest. So that has been removed. However, of course, the flavor remains the same. Instead of EOI, now you are directly inviting the resolution plans, and only those plans that meet the eligibility criteria will be considered. So instead of, they wanted to save the time, so they would have removed this EOI submission and preparation of list of in preliminary and final list. So directly the invitation for resolution plans will be published, and that will be in form P11, and this is stipulated in regulation 43. And this invitation for resolution plan shall be made within 21 days from in commencement, and also has to be published on the website. But this 21 days is a very important element we will discuss in the next slide. Next comes the presentation of plans. So this is again the same role which we had. Even though the code says only the plans which conform to 32 shall be provided to the COC, as we all know, in the ArcelorMittal, Supreme Court clarified that we have no role to decide. So the only role we have is to present all the plans and then give our due diligence report stating this doesn't meet or meets 30 subsection 2. And finally, the most important role is to filing of application to the adjudicating authority. It can be for approval of a plan or termination of a prepack insolvency process or initiation of CIRP. You see, the next two are very interesting elements as to termination and initiation of CIRP. And as you can observe, there is no application to be made for liquidation at all, right? So what are this termination initiation? We have slides covered on that too. Now, we were discussing from the beginning as to why will there be a withdrawal of DIP model, withdrawal of debtor in possession model. Why should the management be vested with the CD, right? So now, just let us set the default rule first. Section 54H precisely covers the debtor in possession model. It clarifies that the management of affairs will continue to vest with the board of directors or the partners, as the case may be. Now, when does this default vested with the RP, right? So the code did not actually stipulate on what conditions COC can take such decision. So maybe it is left to their commercial wisdom. However, when such decision is made by the COC, RP shall file an application with the adjudicating authority, and such application will be made in form P14. So here, adjudicating authority shall have to make a certain opinion. So shall have to form an opinion. What is that opinion the adjudicating authority forms? Two things. Either the CD is running the affairs of the corporate debtor during PPRP in a manner which is fraudulent or which is grossly mismanaged. So either there is a gross mismanagement of affairs or fraudulently it has been undertaken during the PPRP period. In such cases, if at all adjudicating authority is satisfied with that, then adjudicating authority. So here I'm talking about the green tick. So is the adjudicating authority of such opinion? If your answer is yes, then the adjudicating authority will, by way of an order, vest the management powers, all the management of the CD with the resolution professional. So this is a very important point to be noted, because you're as good as giving a flavor of CIRP here. That's why if you look at the sticky note, once such order is passed, all other powers, duties, moratorium, which is generally applicable in CIRP, will come back, will bounce back and apply in this case as well, even though for the sake of it, the name is still PPIRP. So during the prepack, if the CD feels that, so I mean, assuming this, if adjudicating authority has to be satisfied that there is a gross mismanagement or fraudulent or there is a fraud, it itself indirectly means even COC should have censored such gross mismanagement. So in such cases, only we can assume that COC comes out with a resolution. Now, what if adjudicating authority says that, boss, no, there is no such gross mismanagement, this is wrong. In such case, your default rule is already there. The section 54H will continue to apply. So this is with respect to vesting of management. So now let us connect the dots. Once this order is passed, once the debtor in possession is withdrawn, once the default rule is set aside, and once the RP steps into the shoes of managing the affairs of the corporate debtor, then the costs involved will be higher, the fee payable should be higher, and all of it will be counted or all of it will be covered in your pre-pack insolvency resolution process cost. So that is our first dot. Second dot, that is a moratorium. We saw in the slide that section 14(2) and 2A with respect to supply of essential services will not apply. But now, as and when the management is vested with the RP, that will come back into play. That will again apply. 3, the fee payable to the RP. right at the time when the RP is appointed as an IP or proposed to be appointed as an IP by 66% of financial creditors, not COC, financial creditors. At that point itself, the financial creditors should have given the fee payable to the RP in an event where the RP has to manage the affairs of the corporate. So now the dots get connected with the help of section 54J. So this is the section where a debtor in possession model can be completely withdrawn and the default rule be set aside, and let RP step into the shoes and give it the name, let the name be PPIRP, but give it the flavor of a CIRP. So this is a very important section because only this is the only section, or the outcome of this section can only be a ground for liquidation. Otherwise, there is no way you can directly go into liquidation. So we will also discuss it at a later slide, but just wanted to put the point in your mind here that only when there is a gross mismanagement and adjudicating authority passed an order vesting the powers or vesting the management with the RP, only then there are two situations where you can go for liquidation. We will discuss it. So this slide, I believe, is very important for us to know and kind of litigative as well. So now let us discuss the core of, or rather the major change brought forward in terms of approval of plans. But before I go into it, let me just briefly explain you the timelines, which I've already briefly covered. See, the timelines are all initiated from the prepackaged insolvency commencement date. So this is very clear. So all the timelines are from the commencement date. So all the dates you see are from the commencement date. So now, firstly, within 2 days, what is supposed to be happened? There has to be a public announcement. And secondly, the details of claims have to come. Preliminary IM has to come from the CD, and the base resolution plan also has to come from the CD. So that is important. And as we have seen, public announcement has to be made to those who are in the list of creditors. So now the list of creditors will be given by the CD to me. So within the 2 days, both of them should happen. Then within 3 days from the ICD, I'll have to appoint registered valuers. It's actually 3 days from appointment of a RP, but still it is, parallel to the CD. So I took the liberty there. So see, within 3 days, the registered valuers have to be appointed. Within 7 days, COC has to be constituted based on the list of claims confirmed by the RP, which we have discussed. Within 14 days, you have 2 things to do. Number 1, convene your first meeting of COC. And second, within the 14 days, see here the word, don't take this days as the exact date, it is within those days. So within the 14 days, you will have to also submit the IM to every COC member, taking the confidentiality and other aspects. So even those procedural aspects have to be kept in mind. At the risk of, I don't want to repeat it because it's the same as in CIRP.
Sorry to intervene. Prakul, you need to speak little louder, please.
Sure, sir. Sure. So within 21 days from the insolvency commencement date, you will have to invite the resolution plans. That is, you'll have to come forward with a publication for invitation of resolution plans, and that will happen within 21 days from the commencement date. So now, after the invitation for resolution plans has been made, the regulations state that at least 15 days time period shall be provided for submission of plans, which means within 36 days, or rather 36 days might be a trigger. But since it is a time period which can be changed, I did not include it on the slide, but just keep it on the mind that within at least 15 days time period shall be provided for submission of plans. Then within 30 days, the RP shall form an opinion on avoidance transaction. Within 45 days, the determination of amount, and within 60 days, filing of such avoidance transaction application with the adjudicating authority. So these are the new timelines. And the the outer limit we know is with respect to the prepackaged insolvency commencement date. From the prepacks commencement, within 90 days, the prepack process has to be completed. And here, at the end of 90th day, either I'll have to submit a plan with the adjudicating authority for approval, or I'll have to get the plan approved by the COC, or I'll have to file an application for termination. So the law, at least for now, did not provide for any provision for extension of the 90 days period, at least for now. Next, within the next 30 days from the date you apply, the adjudicating authority shall either approve the plan or reject the plan and terminate the process. So the upper limit again here is 120 days. So 90 days is for us. So as far as we are concerned, we are not supposed to look into 120 days. Adjudicating authority might even take more than 30. We are not aware. But as far as we are concerned, our role is to finish it by 90th day. Either file an application for approval or for termination. So that is how the prepack timeline has been stipulated. Now, so if you look at, just that this timeline, in this timeline, one important element I would like to highlight is with respect to where is that the pre-pack flavor has come in this. See, a pre-pack is meant to make sure that something which is pre-arranged is approved. So where is the base resolution plan approved here, right? So we will look at it on the next slide, but just have one point in mind when we are discussing the next slide, that within 21 days, you will have to invite the resolution plans, which means within the first 21 days, you'll have to decide whether you are approving a base plan or you are inviting plans from the public. So just with this, let us go into the main slide of our presentation on how the resolution plan is being approved. So the first step, again, this is completely from section 54K. So the first step is for the corporate debtor to submit the resolution plan, that is the base resolution plan, which I will refer as BRP. So BRP is the base resolution plan, which shall be submitted by the corporate debtor to the resolution professional within 2 days. So that is where everything starts. Now, the RP will present the plan to the COC because the RP had already given in the report, which is filed with the adjudicating authority, that the plan meets the conformity of section 32, such as section 31 and 2. Now, when the plan is submitted to the COC for its approval, what happens in the COC? COC will look into the plan. In the plan, whether the base resolution plan, that is a BRP, is it providing full payment of confirmed claims of OCs? That means, is it providing any impairment to OCs or not? So impairment means where full payment is not made. Hence, I wrote it as if whether full payment is made or not. So for OCs, if 100% payment is made, then that is the green tick. So let's go on the green tick now. So where 100% payment is promised to the OCs in the BRP, then the COC may approve the plan. There is no obligation on the COC to 100% take it for approval. That is point number 1 to be noted. Now, what happens if COC approves the plan? We are all clear. Then RP will immediately submit the plan with the adjudicating authority. Then the adjudicating authority will look into whether the basic requirements are met, that is under section 31 and 2. And then adjudicating authority will pass its order, either approving or rejecting. This is clear. And this is the ideal scenario for a prepack. So the ideal scenario for a prepack is BRP should not provide any impairment, that is full payment has to be provided to the OCs, and the COCs will put it for voting and COC will approve it. So that even within 30 days, you might complete the entire process, wrap up the PPRP and then say hi, hello to everyone. However, that might not necessarily be the case. So along with prepack, we had a hybrid model of analyzing the resolution plans. So what happens? Let's just go back to the step. Again, coming back, the COC is looking into the plan. Whether the full payment is provided, yes. But whether the COC approved it, no. The COC does not approve the plan. So the COC does not approve the BRP. It doesn't mean end of the process. It doesn't mean we should terminate the process. It means we'll have to go to the next step, that is invitation of resolution plans within 21 days. Right? So this is a very important element which we'll have to put in mind. So non-approval of the base resolution plan does not necessarily terminate the process. This I'm talking about the initial stage. This is highlighted in section 54K subsection 4. So COC may approve the plan, and if COC does not approve, then COC shall invite the resolution plans from the public. So that is important. Now go back to the step again. Whether the BRP provides full payment, if your answer is no, then you will not even go to the next steps to the right. You will directly invite the resolution plans. So RP has got this responsibility to look into. When you present the plan to the COC, then COC looking at the plan will say, yes, this plan is providing full payment, boss. Let us decide, should we put it for voting or let us not approve it and go for invitation. Where the plan does not provide full payment to OCs, no questions asked, directly go and invite the resolution plans. And that is where our next step comes into picture. So I hope we are clear here. So first is submission of plan to the RP. RP is presenting the plan to the COC, and COC looking into the BRP on one important aspect. Has full payment been proposed to the OCs or not? Operational creditors. Yes, if your answer is yes, take approval from COC on it. If approved, well and good. If not, invite from the public. Invite resolution plans from the applicants. If the plan does not provide for full claims of the OCs, then you'll have to essentially invite plans from the prospective resolution applicants. Now let us go into this aspect of invitation of plans, which means from Prepacks, we are coming to a hybrid model, which is proposed in this ordinance read with the regulations. So what should the RP do? RP should should publish invitation for resolution plan. Just like RFRP, this is IFRP. And such IFRP shall be in the form P11. Now, when we are inviting a plan, the invitation should contain the eligibility criteria. It should contain the basis of evaluation. It should contain the criteria for ascertaining whether a plan is significantly better. And it should also contain a criteria which is called as tick size and how a plan can be improved. So these all might sound vague now. As I take you along the process, things will become clear. So now when the plans are invited from the prospective resolution applicants to compete with the base plan. So highlight this word, which is very important, competing with the base plan. So the whole objective of inviting plans is to compete with the base plan. So why the reason I wanted to highlight this is that just because COC did not approve or just because the base plan does not provide for full payment to the OCs does not mean the CD is out of the game. The CD is in the game till the end, right? So now let's go to the next step. So the next step is basically, I just skipped one step here to make sure the slide looks easier and smaller. The next step is actually to give the evaluation matrix, that is the base of evaluation. I am giving the IM to the PRS. So that is again important to only those who meet the eligibility criteria. So that is the next step, but I skipped it because that's a standard step in a CIRP as well. Next important aspect is with respect to selection of a plan. Now, when the plans are submitted, I'll have to evaluate the plans based on a basis of evaluation. So regulation 42 in the PPRP regulations had come out with 3 definitions. One, that is basis for evaluation. So earlier we had the evaluation matrix. So I think it's on the same lines that they have come out with this term basis of evaluation. In the basis of evaluation, you can come out with any number of criteria, but the basis of evaluation should essentially be to assign a score to a plan. So if 4 plans, assuming 4 plans are submitted, each plan should be in a position to be scored. That should be the agenda behind basis of evaluation. So based on the evaluation, all the 4 plans will be evaluated, 4 different scores will be given, and the one which is having the higher score will be the plan which will be selected, right? And this plan which is selected is what is the plan which we assume as X. Sorry, there's a small correction here that it's not select the BRP, it is select that best plan, not it's supposed to be the best resolution plan. I'm sorry, I unnecessarily gave an acronym here. It's supposed to be selecting the best resolution plan. So if 4 plans are submitted, of the 4 plans, which is the best plan based on the basis of evaluation, the score assigned on it, select the plan. Now, for the sake of simplicity, I am assuming that plan to be X. So when I say X, it is this best plan out of the plans invited from the public. It is not the best plan compared to the BRP yet. So don't go to that decision. So now we are clear. I invited resolution plans from the public. And once the plans have come, I have selected one plan, which is the best plan among them based on the basis of evaluation. Now comes the second step. Is that plan X significantly better than your BRP, that is the base plan? That is where the next definition of regulation 42 from the IBBA regulations can be referred to. What does it say? It says that give a number, let us say some percentage. Is this particular plan better than the other plan by way of X percentage? If it is yes, then it can be considered as a significantly better plan. So the ordinance basically says that the COC shall lay down a criteria, but which is subject to the conditions specified by the IBBA. So IBBA did not specify too many conditions, but it only basically said that was such number has to be provided in the information in the IFRP, that is invitation itself, as to what is the percentage you are looking at when you are comparing it with the BRP. How much, I mean, on what percentage basis is it better compared to a BRP? Example, I give, let's say 5% is better than 5% than the base plan. If base plan is 100, assuming the figures from the illustrations, so 100, which means if your X is 106, which means the score of X is 5% better than the score of BRP, then yes, X is significantly better. If it is less than the 5%, with let's say the score of X is 104, then X is not significantly better. So we are clear here as to whether X is significantly better or not is based on a certain percentage on a BRP. If it is exceeding that percentage, it is significantly better. If it is not exceeding, then it is not significantly better. But what is the effect of this? What is the effect of this exercise? Let us look into that. So now I request you to focus on the left, the below part of the plan. I mean, on the bottom, the left bottom, as to what happens after a significantly better, I mean, if after looking into the question as to whether X is significantly better or not. The green tick signifies yes, it is significantly better, and the cross tick, the cross signifies that it is not significantly better. If it is significantly better, right now let us be optimistic and go and see that the plan which is selected is significantly better. Then again see the wordings used. Then such plan X may be selected for approval by COC, which means COC will again have an option to think, should I take it for approval directly by passing 66% or not? Let us say COC thought, why not? Let us approve it. I've got a better, significantly better plan. It is having good percentage. Then COC will put it for voting. If 66% voted, well and good, you will go back. RP will submit the plan to the AA, and which will either be approved or rejected, and the process is terminated. This is fine. But what if COC decides, why not we go for a competition? Why not we have the competition between these two plans? Right? Even though it is significantly better, maybe the CD will come out with much better plan than this fellow. Then why should I lose on that opportunity? So that is why I think the logically COSP has been given an option not to consider a plan even if it is significantly better for approval. So a plan which is significantly better may still not be considered for approval by the COC. Then that is one aspect. Second, let us say the plan is not at all, I mean, it's not significantly better, which means it is the BRP is better than the plan. So in these two cases, that is in a case where a plan is significantly better, but still the COC decides not to consider it for approval, or a plan is not significantly better, then such plan X shall compete with the base resolution plan. And it has to be in a manner specified by the IBBI. So what did IBBI specify, right? So I just will quickly revise this step, that after the significant, so we have seen that the plans are invited, best plan is selected, it is compared with the BRP. If it is significantly better, COC may vote on it. If it is not significantly better, COC has to necessarily compete that plan with the BRP. Even if it is significantly better, COC has an option to go back and ask the base plan to be compared with the X plan. Now, how are these two plans competed? So for that, I will for a moment go on to the next slide and come back. So how are they competed? So for the sake of competition, Regulation 48 stipulates that RP shall disclose. So what happens here is X. So till this process, the score of X and the score of BRP are known only to them respectively. It is not disclosed to each other. But now, since you have decided to compete with both of them, you will disclose these scores to each of them. So X will now know what is the score of BRP. BRP will now know what is the score of X. Then RP will invite the submitters of these respective plans, that is the CD as well as the applicant of X plan, to improve their plans. And all of this process should be completed within a time window of 48 hours. Now, how is this done? Let me take you through by way of an illustration. Let us assume the score of the plan X is 100, while the score of the base resolution plan is 108. Sorry, it's again a typo. It's BRP, not BSR. Let's say the base resolution plan is 108. So now, as you can easily identify that X is having a lower score. Now, for a moment, forget whether base resolution plan is significantly better or not. Let us take a decision that the COC decided that it has to come into competition. It has to be competed. They have to improve their plans. I mean, you call it Swiss challenge or not, but this basically is an improvement, because the code or the regulations did not specify this name Swiss challenge, and hence even I am not specifying or stressing on it. Now, let's say the score is 100, which is the lower score, right? So the regulations state that the submitter of plan of the lower score, so that the resolution applicant of X plan will have an option to improve the plan by at least a tick size. Now, what does this mean? So this is the first and the foremost step, is to look into the scores, and whosoever is having the lower score will be given the first option to improve their plan by at least a tick size. Now, what is this tick size? Let us assume tick size is 8. Okay, but what is tick size? Regulation 42(3). So as I said, Regulation 42 defined basis for evaluation, significantly better plans, and the third one being tick size. So what does it say? Is tick size is the minimum improvement over another plan in terms of score, right? So what does it mean? Now let's go to the right hand side of this particular slide. In the right hand side, go to the box, right? So look at this box. This is important. Assume, see, firstly we know that in this illustration, X will have the first option to submit, right? So when X is having the first option to submit, X has to improve the plan in order to make sure that the score of the plan will turn out to be better than at least a tick size over the base resolution plan. So now the submitter of X plan will improve the plan such that the reassigned score is score of the BRP plus tick size. So if you ask me a simple addition or a mathematical formula, it has to be score of the other plan. In this illustration, it is the base resolution plan plus the tick size. So here tick size is a standard number. So assuming our tick size is 8. So if you see here in the first step, so if you see this particular exercise of option, X has first exercised this option and it improved its plan to make sure that the improved score shall be at least 116. And how did I come to 116? I went back, I took the score of BRP. So over here, if you see in the table, in the box, the improved score in the first round for X is 108. That is score of BRP, right? Plus the tick size. So the formula, I just stuck to the formula. So the tick size is 8. So now the criteria you should put in your mind is when we are improving a plan, we should know what is the other person's plan. Assuming I am the base resolution plan applicant here, and let's say you are the resolution applicant of X, then you know my plan now. So you know that my score is 108. And you know in the invitation for resolution plan itself, they have given the tick size as, let's say, 10. So you, from your score of 100, you'll have to come to a position where you are plus 8 of my score. So my score is 108 for now. So which means you will have to go to a level where your score is more than 8 of my score. And 8 is a whole number here, not a percentage. So from 108 over and above the 108, the tick size will come into play. So you will have to minimum come with a score of 116. Now that you became 116, so next step, I will become the person with the lower plan. So I am the base CD submitting the base resolution plan. So now I have the lower score. So now it is my option to submit a plan, which will have a revised score better than your plan. That is better than X's plan. Now the X's revised score is 116. So for me in the formula, I'll have to put 116 plus the tick size, which is 8, which means my improved score should be at least 124. So next, again, now X becomes the lower score. So X comes with a tick size, taking 124 as the base, plus the tick size, 132. Now I became the low score. So this process will go on till the time any person fails to exercise the option. So let's say in the last stage, I submitted a plan with an improved score of 156. Now you have an option to beat my score and come with a score which is better than 156 plus the tick size, which is 8, which means 164. Let us say you are not intended to do that, which means you fail to exercise the option. In such case, this base resolution plan shall be selected for approval. This does not mean that at the end the plan is approved. No, it only is a process wherein the best plan among the BRP and X basically both the plans are put to a competition. You can call it a competition to improve each other's plans in a way that it is over and above the other plan by a tick size. And such tick size will be provided in the IFRP. So this process entirely has to be finished within 48 hours. And in fact, for this processes, COC can even stipulate the timelines as to within what time they'll have to come submit the options and all. But overall time period which is provided is 48 hours. So this is how the plans will be improved and either of the plan will be selected. I hope it is clear. So I'm going back to our slide to go back and start off resume from that position, that place where a plan is ordered or rather decided to be competed with the base resolution plan. So now X, which has passed the tests of significantly better and then came here, is now is being competed with the base resolution plan. We have seen in what manner it is being competed. Then at the end of the process, the person who failed to exercise their option to come out with an improved plan over and above by a size of tick size, if they fail to exercise that option, the other plan which is having the higher score will be selected for approval. So the word selected is very critically used in this 54K. So we'll have to clearly highlight it. That's why I kept it in green. So it has to be selected for approval. So now over the process, either X might be selected. I mean, your plan may be selected or my plan may be selected, PRP. Then whatsoever be the plan which is selected, it has to go it has to be approved, right? The COC may approve such selected plan, which means after that competition, whosoever wins, in the sense whosoever gives the best or the high ends up having the higher score, that plan will be put for voting with the COC. And if COC approves it with 66%, again the drill is the same. If COC rejects it, then the RP shall file for termination of the plan. So termination again is a new concept, because in CIRP we don't have a concept of termination. Either you can liquidate or approve a plan, but here you can terminate the process also. So once it is terminated, it is again the CD will continue in its own control. So it's just like a failed prepack. So this is the entire process of approval. A quick recap. Once a plan is submitted and presented to the COC, first important question is whether the base plan provides for full payment. If your answer is yes, COC might approve or might not approve. But if COC does not approve, it can come back and invite the plans from public. But where your plan itself does not provide full payment for OCs, no questions asked, boss, just go invite the plans from the public. Then evaluate the plans basis the base of evaluation, select the best plan out of it, which is having the highest score, and compare that plan with the base plan. Is it significantly better? Yes. Then decide, do you want to vote it? Vote. If you don't want, then again you come back and go into the process where the plans will be competed in the manner specified by IBBI. If at all it is not significantly better, again no questions asked. Go into this particular competition spirit. So what happens in the competition? The scores of both the parties will be disclosed to each other. So I know who is the lower scorer. The low scorer, the lower score submitter, the submitter of a plan which is having lower score will be having the first option to exercise, wherein he can submit a revised plan which will increase the score of that plan by a tick size. And that is nothing but the score of the higher scorer will be taken and it will be added with tick size. If you can meet that score, then only it means you have accessed the option. Then once you access that option, you are the top scorer now. I am having the lower score. So then I will compete. I will access my option. So we two will compete in a way wherein one of them will withdraw from the process and the other person who has the high score will be the one who will win the process. And whosoever wins the process, that particular plan will be put for voting before the COC, and the COC may approve it, in which case adjudicating authority shall approve or reject, and COC may reject it, in which case it has to be terminated by the RP. So this is the entire procedure on approval of plan. I think I've taken more time. I will now quickly, because now there are not many slides, I will quickly wrap up the session of my presentation. So the plan shall provide for, firstly, there are a few important elements I just wanted to quickly highlight, that the basis of evaluation has to be provided in the IFRP. The RP should provide it along with IM to the applicants who are meeting the eligibility criteria. Second, if you have seen that the base plan should have been voted at least 21 days, before the 21st day, because 21st day you have to go invite the plans if you want. If not, you're out of the process. So which means the COC may provide certain opportunity to the CD to revise the BRP. So it should not be so stringent that initially within 2 days, whatever the BRP is filed, that will be standard. He cannot change. It's not like that. Let's say 100% payment has been given to OCs, but FCs have been given certain haircut. So COC might negotiate it and ask the CD to come with a revised plan. So that option is there, but it is only till you invite the plans from public. The moment you invite, you cannot give an option to revise, because you'll have to freeze the score of the BRP. That's why. Next is the CD may submit the BRP either individually or jointly with any other person. So it's basically an option given, either you come individually or jointly. And next is another very important point as to impairment of any claims which are owed by the CD, right? So those claims which are confirmed, which are owed by the CD, if there is an impairment provided in the plan, which means if the plan provides 100% payment to OCs, but there is impairment to FC, or there is impairment to both FC and OC, or there is impairment to OC but not to FC, whatever be the scenario, where there is an impairment of any claims, then the plan should ideally provide for dilution of dilution of stake or dilution of shareholding or voting rights or the control rights of the promoters in the CD. However, if the COC is still approving a plan which had provided for impairment of any claim, let's say OCs are provided but FC has not been provided 100%. In such case, the COC should give it in writing, shall record it in writing as to why, the reasons behind such approval where there is a impairment of the claims, right? So here this impairment should not be equated with impairment of merely the OCs. This impairment is of any claims, right? So these are the 4 points I felt which are important to be noted. And now, as I said, the CIRP process has provided for termination of a PPRP, and termination has been dealt with in different sections. Section 54N is the primary section in which the adjudicating authority will pass the order for termination, while section 54O and L have also provided certain grounds. I'll quickly take you through the grounds. The first one being that COC did not approve any plan, right? So let's say you have competed. We have seen how the competition is done. So the tick size has been provided, competition has been done, plans have been improved. Let us say BRP X plan has been put for voting after the competition. It is selected and put for voting, and COC rejected that plan. In such case, you will have to, the RP has to file an application for a termination, right? So that is, in a sense, it will actually get terminated only. So that is the termination. In cases 2 and 3, that is 2, which is no resolution plan is approved by the COC within 90 days, which means the maximum period no plan has come, or COC with 66%. So COC has been provided with an option to terminate the process, not to liquidate, but to terminate the process. So if COC feels this CD had initiated with only causing some trouble, in such case, COC can terminate the process with 66% voting share. And even if you observe under 54J, where we discussed that there is a vesting of management with the CD, so sorry, with the RP, where adjudicating authority orders, so adjudicating authority shall form an opinion, right, that there is a gross mismanagement. Let us say adjudicating authority said no, there is no gross mismanagement, but COC still feels I don't want CD to be in control. Then this is the best way out: terminate the process. Or the other best way out for you should be initiate CIRP. So migration into CIRP is also provided in PPRP. I will comment in the next slide. Now the fourth ground is with respect to initiation of CIRP. So this is what I was referring to, migration to CIRP. So during the PPRP itself, you can migrate directly into CIRP if the COC decides by 66%, right? So this is provided under section 54O. However, at the time of passing such order for initiating CIRP, the adjudicating authority shall firstly terminate this process of prepack, right? So the end of prepack is termination. So that's how we should remember it. And then fifth point is with respect to adjudicating authority rejecting the resolution plan as it is not in conformity with section 30 subsection 2. So where a plan is, so this is again clear. So where a plan is not meeting the requirements under CIRP, the adjudicating authority shall liquidate, whereas under PPRP, adjudicating authority shall terminate. And the last ground, another interesting ground, this is with respect to vesting of management with this RP. So where adjudicating authority says, yes, there is gross mismanagement, we'll have to withdraw debtor in possession, let RP be given the management powers. In such cases, the RP will be in control. However, COC ended up approving a plan which does not provide for change in management. What does that mean? It means COC itself says there is gross mismanagement, but COC approves a plan which does not affect change in management. This is something which is not tolerable. So the adjudicating, the section 54L clarified that in such a case, adjudicating authority shall terminate the process. Along with termination, adjudicating authority shall pass an order for liquidation as well. So that we'll discuss on next slide. But still, the effect of vesting of powers with the RP is quite vital. That's why I highlighted it in that particular slide. Now, whenever the RP is filing an application for termination, it has to be filed in form P13. So that is something which is important. And let us say let's say the PPRP is terminated. Then what happens to PPRP cost? What happens to the fee of the RP? That has to be borne by the corporate debtor. So your separate bank account should help you with that, where you have the operation. So the money will be deposited there from time and again, or the CD will have the responsibility to bear all such costs. And then once it is terminated, there is a let us say the RP had initiated avoidance transactions. So does it mean avoidance is also terminated? The answer is no. But the adjudicating authority has been provided, is given a responsibility to provide the manner in which such proceedings shall continue. So this is with respect to termination. And coming to liquidation, before I liquidate my presentation, is with respect that, as I said, liquidation, direct liquidation. So firstly, take your attention to the sticky note on the slide. You cannot directly order for liquidation. So the COC cannot decide to liquidate at all. There is no power of COC given in the prepack or in the ordinance to liquidate the CD. So in what situations can liquidation happen then? Only when there is gross mismanagement, and only when adjudicating authority is of the opinion that there is gross mismanagement, where COC passed an approval of 66% and adjudicating authority by way of order vested such power with the power of management of affairs of the CD with the resolution professional, only then there can be a situation of liquidation. What is that situation? Situation number one is where the COC, even after knowing that the existing CD is grossly mismanaging the affairs, still approves a plan which is not affecting change in management. In such case, as I said, it is not tolerable. So the adjudicating authority shall liquidate that particular, shall order for liquidation, right? Second situation is where no resolution plan is received within 90 days. But here, it's not in general, it is only in a situation where powers are vested with the RP. So as I time and again told you, once the powers are shifted with the RP, it is as good as a CIRP. So consider it as a failure of CIRP. The failure of CIRP leads to liquidation. So where the management has been vested with the RP and subsequently no plan has been received within 90 days, then there is no other go. You can't go into CIRP. You will have to liquidate it. If you want to go into CIRP, you will have to terminate the process and then enter into CIRP. There is no other, or you can order for, you can approve a CIRP directly. But if no plan is received within 90 days, it will be essentially liquidated if RP is exercising that management powers. Then finally, where let us say everything went smooth, new plans have also come, they have been completed with the base plan. Because now see, effectively, so which means you have only ended up with one plan, even though it competes with the base plan, I don't see a drastic change in management. So even after that process, no plan has been approved. In such cases, also liquidation shall be ordered. Alongside this, the section 33, if you remember in the same section which says that where there is a contravention of plan to the concerned CD, it will amount to liquidation. I mean, the adjudicating authority may pass an order for liquidation. Plan approved under, and then the adjudicating authority shall pass an order. The adjudicating authority shall also declare that such PPRP costs liquidation costs, right? So this is about the liquidation, the migration into CIRP. So section 54O provides that during the process, during the period of 90 days of the PPIRP, if the COC by way of voting 66%, right? So at any time after commencement, but before approval, % of voting if resolved to initiate CIRP
We can't hear you, Prakul.
I'm sorry, there is some mistake from my end. I'm sorry. One moment, I'm just checking my screen.
Yeah, no worries.
Yeah, I'm really sorry. It's almost done. Is the screen visible, ma'am?
No, not now, Praful.
Yes,
not
sir.
now.
Yes, sir. Sorry, sir. Yes, sir. I'm so sorry. Some trouble on the net. I'm so sorry. So yes, we have seen that. Yes, sir. Yes, sir. So we have seen that the COC by 66% voting share had resolved to initiate the CIRP against the CD, in which case the RP will intimate the adjudicating authority that a decision has been taken by the COC to initiate CIRP. Once the intimation is made to authority, the authority will now, by order, firstly, it has to terminate the PPRP. Secondly, the existing RP who is looking after the PPRP shall be appointed subject to the consent of the RP, will be appointed as IRP in CIRP. So it will be the same role. It's not like it will continue from day 30 or 40. It will again start from day 0. He would be an IRP, so he would invite resolution plans, everything of that nature. And then the PPRP cost shall be declared as a CIRP cost. That is fine. But there are 5 important points which I wanted to focus on. The first one is with respect to the order being deemed as an order of admission under Section 7. So this sets the ground rules clear. So where an order for initiation of CIRP is passed by the adjudicating authority during a PPIRP, in such cases, such order shall be deemed as order of admission under Section 7, and everything else which would apply in a conventional CIRP shall apply as if it is admitted under Section 7. Number 2, the commencement date of such CIRP shall be the date of the order of the adjudicating authority. Number 3 and 4 and 5. These 3 are a bit intertwined. So what is number 3? The number 3 is already there are pending avoidance transactions which would have been filed within the 60 days time period. What happens to that? It will continue. They will continue right from the beginning of the CIRP. So the litigation can continue. There is no need of, there might be again an RP looking into it, might come with new transactions, but the existing avoidance transaction shall continue. Next, point number 4 and 5. Very important. See, generally the clawback period provided under Section 43, 46, and 50 is 1 year in case of non-related entities, 2 years in case of related. Of course, for extortionate, it is only 2 years. But the trigger is prior period. So it is 2 or 1 year respectively prior to insolvency commencement date. However, in case where the CIRP is initiated during the prepack, in such cases, that insolvency commencement date shall be read as prepackaged insolvency commencement date, which means the 2-year period or the 1-year period shall be preceding the prepackaged insolvency resolution process period. But there can be a question, and what if there is something happening during the PPIRP? Is it out of the ambit? The answer is no. This period of PPIRP will be an additional period which shall be included in the clawback period or the lookback period. So that is point number 4 and 5, which are very critical to my understanding. So this is about migration into CIRP. A quick summary: we have seen how the applications, how the PPIRP, the before initiation, the role we have tried to understand what kind of role an RP has or an IP has and what other different things have to come, the eligibility conditions, then the declarations. We have seen the FC approvals, 2 different meetings, and then we have also seen that an order is being passed, at which time RP should give a report on whether the conditions are met, whether the base resolution plan is in compliance. Then we have seen that upon admission, upon admission, the base resolution plan may be voted upon. Post that, there can be invitation of plans from the public. Then where a plan has come and been selected, you can have a competition based on the tick size and then select a plan, go for approval. If not, there are 3 situations: either the plan may get terminated, it may get liquidated, or the COC might even pass an approval, pass a resolution for migrating into CIRP. And again, I go back to that one important provision where during this PPRP, a debtor in position can be withdrawn. Even that has been provided for. So this is with respect to the ordinance, read with the rules and the regulations made thereunder. I'm so happy, and also I'm very thankful that all of you have been very patient enough. So if you have any questions, please keep posting. We can see that many questions are already on the session. So keep posting the questions. And now I open it to Abhijit sir. Thank you so much, Abhijit sir, for giving me this opportunity, and all other panelists for encouraging me to take up this presentation. And I think now, sir, I'm so sorry for exceeding my time, but I think it deserved that amount of time. Thank you so much, sir.
Absolutely, it did, Prakul. Thank you very much. I think it's one of the most enlightening presentations I have heard in a while.
Thank you, sir.
To the point and thorough, at least it gives us some good knowledge about what the sections of the new ordinance is and the rules that came out yesterday. And your ability to turn around the rules overnight was, I think, phenomenal. So thank you for that, Prakul. Now, I had a bunch of questions. Can we please have everybody on mute, please? It's important. We've noted your questions down, and what I have been doing for the last 1.5 hours is listing down key questions raised by most people so that we can answer some of them through this panel here. Now, I don't claim to have any expertise because I don't do SME accounts. But we have an extremely good panel here. Rathi ji, Snehal, Yogesh ji, and of course, Dr. Benani, who will answer most of our questions. And Prakul, I would appreciate if you come out on the technical points or some things that we could have missed off.
Certainly,
Now,
sir.
just a small preamble before I start this short discussion. And I promise we will end by 1 o'clock. I don't want to have more than a 10-15 minute discussion around this and another 10-15 minutes of additional Q&A. But really, and I'm not the person who will stand between you and lunch ever. So to be least assured, only one thing I want to mention, that this pre-pack regulation is a mindset change. And I saw many questions where people said how value discoveries will happen, how the process will be followed. One thing you have to remember, a pre-pack, by what it means, is a solution which is worked out much before the CIRP process is entered into. It is a change in mindset. The only thing that the rules tend to ensure is that there is a fair play and people have been dealt fairly. Financial creditors are known to be superior creditors, and when they take decisions with their eyes open. So as long as you have a 66% approval, it's fine. As long as all operating creditors are paid in full, you're fine. Why should there be a value discovery? Because everybody has been paid, and whoever is not being paid or may not be paid is taking a decision with their eyes wide open, and they are sensible people. The other thing that is the biggest advantage of a CIRP is that it binds every creditor as long as there is majority, which is by far the biggest issue in any resolution. Somebody or other will come and poke a hole and try to gain advantage where you only lose value. And my own experience says that whenever you try to maximize value, you lose value. So the idea is, in an insolvency or a turnaround, is the sooner you conclude, the better. And that is the prime objective, in my view, of a pre-pack regulation. So I will quickly come to some interesting questions that were raised. And Dr. Binani, I'll start with you because it's always ladies first. The question I have for you is a combination. I'm just trying to merge a few questions that were asked. The big issue that seems to be is this conflict issue. Now there is somebody who is going to talk to their MSME client and say, why don't we go for a pre-pack? And he will agree to a pre-pack. And then there will be some help in preparation of a base plan. And then there will be this whole IP process after initiation that will start, as explained by Prakul in the presentation. Do you see a conflict of one person doing everything, or will this job get divided among 2-3 people?
Honestly speaking, Abhizar, there is no conflict at all. Actually, this is more of a restructuring exercise than a proper CIRP that we have been seeing it through. I think all the professionals that we are all here, we were discussing this yesterday also threadbare, that let us not juxtapose this with the CIRP that we have been seeing for the last 4 years. It will be more of a restructuring exercise where we were saying that, I had to pay you money in 3 years, 4 years, I've turned NPA for whatever reason, and probably this restructuring will let me pay in the next 7 years or, whatever. So that's the kind of approach that I see in this PPIRP. That's number one. Number two is government brought this PPIRP with a basic objective that jobs should not get lost. And because these SME or MSME companies are not asset-heavy companies, so there are not many buyers in this sector. And therefore, let the entrepreneurs who have not only put their money, hard-earned money, but their heart and soul into it, should be given the first right of refusal. But having given the first right of refusal, optics-wise also the government had to be very, very conscious and cautious. And therefore, they said we'll have a Swiss challenge kind of an approach, where let the outsiders also come. Now, if you see just the concept of no impairment to the OCs, because the narrative was the OCs itself are most of the time these MSMEs. So the government had this concept very clear that to save one MSME, we should not be putting the other MSMEs into trouble, or maybe to deep trouble, because if impairment to them would also lead them into that mechanism of trouble. So therefore, I think this is a very important thing that the government has brought out, that if you're seeking any impairment to your fellow colleagues, then, we are not allowing you to do so. Now, one very important thing that you mentioned, that is there any conflict? What is the conflict that you're contemplating? Are you saying that there would be a conflict between the...
I'll tell you a simple one.
Yeah.
The person who prepares the base plan,
right?
Can you also be the IP who will measure that base plan against other plans that come?
Not, absolutely no, cannot be. To my mind, I'm very clear that it cannot be. The answer is as simple as that. Cannot be.
So it will be different people. So
Yes.
the consultant, because a lot of the IPs here will be very close to their SMEs, MSMEs. They will have to first go and explain to their MSMEs as to what is a prepack. So the person who does this so-called germinating the idea in the mind of the IP, of the corporate debtor, will not necessarily be the person who will be the IP.
Not necessarily. I think the related party 5/24A will have to be measured. Number one.
No, forget it. He's a consultant. He's an advisor.
So then I don't think there is any reason why he should step back and cannot be.
I think it'll be a challenge even with the lenders to accept him, the person who's prepared the base plan, also to be the person to be the IP. I think there will be some challenge. So that's one. Madam, I'll quickly move to Yogesh ji. Yogesh ji, first of all, there's a debate as to what is the difference between CIRP and PIRP. Why should one choose? How does one choose between the two? But my bigger issue is that if 240A was introduced, which said that 29A does not apply to MSMEs, then what is the difference between CIRP and Prepack? You might as well do either one, it doesn't matter. You get more time, in fact, in CIRP.
First of all, PPIRP is meant only for the MSMEs, as against the availability of this option of CIRP with everyone. Second, the default amount. Default amount under the PPIRP is only 10 lakhs, where under CIRP it is going to be 1 crore and more. These are the two major differences. As far as the section 29A is concerned, it is going to be the same for both the categories. We were thinking that there could be some tweaking in section 29A, but the fact is that it has not been tweaked. And the reason which has been given by Dr. Sahu in his presentation is that they do not want the fraudulent directors or the people who are indulged in fraudulent activities. They cannot become part of the resolution process. They cannot be invited for
But for MSME, there is exclusion. So it doesn't matter whether you take CIRP or Prepack.
No. You see, this fraudulent is not excluded for
fraudulent is not included. So 1 year NPA is excluded and guarantees are excluded.
Yes. So fraudulent, see, major section 29A, whether he is doing some fraudulent activity or he has been declared as a fraudulent defaulter, then he will not be covered. So same provision has been kept under the PPIRP as well, on the same analogy that these kind of people cannot be considered for the purpose of inviting or becoming as a resolution applicant. I think I'm clear on this.
Okay. Prakul, you want to add something? No. Okay, fine. I thought you came online because you wanted to add something. Okay. Okay, thank you. So, Rathiji, question for you. Sorry, before that, Snehal, question for you. One is, why would an MSME want to go for it? If you were an MSME and advising a client of yours who's an MSME, what would be your recommendation to him? Should he actually go for this? Not go for this? What?
First of all, we need to understand the positives of the prepacks. What we have been discussing and what I found that the talk in the fraternity of IPs has been there is the account NPA. Prepacks can go much before the account becomes NPA. This is a mode of restructuring. So where the bank is, this is something between CRP and the restructuring where the bank is doing. So where bank is planning to do or is ready to do a restructuring for certain MSME account, but they have certain reservations due to their internal policies or all. And there, this model of prepack can be of absolute thing where it will click and it will sail through, because their banks will not have a hurdle to approve the base plan. Secondly, the account position will remain good and the continuity will remain. Thirdly, as we say that when it is to be advised to MSME on the prepacks, it is going to be a really challenging thing to advise on this because of the declaration that the MSME corporate applicant has to give. And that declaration has various things where most of the MSMEs are not organized enough, where they will be able to give a clarity on that declaration. So certain things over a period will get smoothened out, and this prepack, I 100% agree that this prepack concept that has been brought in is absolutely excellent concept, but it will take time to settle with MSME because most of the MSMEs are unorganized. They don't have the data readily available, which is asked in the declaration, or which is to be provided within 2 days to the RP for him to work. So a lot of challenges will come on these lines in executing the or in taking the any MSME under Prepack, because that collection of data, a process of Prepack itself is a challenge. So wherever that challenge is overcome, and wherever the data is being able to compile, that companies will be in line with can go under the Prepack in my view.
And you think that MSMEs will be okay with an upfront declaration of avoidance transactions?
So that is what I said. The declaration, that's why I spelled out, because avoidance transactions, when we talk of a puff, basically, okay, I can tell that, okay, fraudulent, they will have many who wants to go will not have an issue on fraudulent. But other three transaction, and especially a preferential transaction, there will be a challenge. What we are talking is MSME. So MSME, the maximum bank limit, what we envisage, because 250 turnover is what is the maximum turnover under MSME that can come. And as per the banking norms, the limit can of our working capital can be maximum 50 crores against that. In most of these cases, what you will find is there may not be too many banks, maximum 2 or 3 banks at the most. But still 75% of this class will be having single bank operations. So where there is a single bank operation, and when you have to take this base plan approval, I think initial work that will be done is very important, because so transaction audit or anything evidence transaction, in my view, the corporate debtor needs to do it beforehand on his own before he takes this, and then he can give declaration. Otherwise, in almost all, I can say you can not almost all transaction, you will find at least a preferential transaction whereby the loans are repaid to others before the financial creditors from whom the loans have been taken. And the agreement, which is a standard agreement by all the banks, which contains a clause that you cannot do that, which itself make all this transaction as a preferential transaction straight on. So this will be a really challenging in this MS.
So corollary to that, Snehal bhai,
yes,
is that if I have preferential transactions,
yes,
in my base plan, would you recommend that this be reversed?
So now it is the size. Practically, it will be very difficult to reverse the transaction. But a disclosure, probably some amendment whereby on this preferential, if the transaction, the disclosure given by the thing, allowing him, because this preferential does not tantamounts to fraudulent. The intent is not fraudulent in nature.
It is only preferential. Preferential means reverse.
Where there is not fraudulent intent, and where there is not in the country where the system is not organized, where the financial discipline is not in place like the overseas places, there probably a leniency on this transaction, at least a preferential. I even not say on the other 3 transaction. Undervalued also I say, or exorbitant transaction also I don't say anything, but at least on preferential, if a leniency is given, probably many MSME may be able to take advantage on these lines. But if this is not given, I think most of them will disqualify in avoidance transaction when it comes to play.
Correct, that's important. Okay, coming to Rajesh, I think a bunch of questions that people asked and intrigued me. Some of them I didn't have an answer for, but I would like to seek yours. One is, there is a section 10 in CIRP which says there can be a self-filing. Is there a self-filing provision in Prepacks, or does it have to be a default of less than 10 lakhs? It's interesting. Somebody raised it. Maybe Prakul can answer it. Rajesh, you are, I think, on mute.
Default has to be more than 10 lakhs, boss.
Correct. So that there is no self-filing provision.
Right.
There is no self-filing provision. I cannot go myself to Prepack and say, I am in financial trouble, please accept my Prepack. I have to go through section 10 of CIRP.
There is no such provision.
Okay. So one is there is no such covenant. That is an important clarification for a lot of people who ask that question. The second is that everybody believes that with all these processes that we have to do, which is verifying, claims can be there.
I'm sorry, I may not share the same view.
Okay.
There's nothing which says that you cannot do it self. So if I have defaulted, which I know I've defaulted, so what stops me to?
No, if you have defaulted, is fine, madam. Question is if you have not defaulted, can you do it? I guess there is no, because under section 10, you don't need to have defaulted.
You have to have a default.
You can still file.
So, yes, Avizar, I have a different view. In the Prepacks, probably when this 10 lakhs has been put as a default amount, and the applicant is a corporate applicant, and the corporate applicant has been well defined. Who is a corporate applicant? The CD himself, the partners, or the directors, the management, who can file these things. So when this Prepack, probably at this point of time, what Yogesh ji said, that there is no provision that if there is no default, you cannot go for Prepack. But in my view, that if I see that if I'm a MSME and my company is going to come in trouble. Now, for example, a very simple example that you can take, these lockdowns have been happening regularly. I am a MSME, and due to this lockdown, I have a serious threat on my business. There may be a corporate guarantees, there may be a guarantees given for the contracts that I have entered into, and I will not be able to fulfill, and that guarantees get evoked, and which is for sure that will not be able to control that, because all guarantees were irrevocable. And I foresee I am getting into the trouble because of that. And in that scenario, as a MSME, probably, if I evoke the Prepack and try to reschedule the things, then I may get a benefit of it. But yes, as on date, I agree that 10 lakhs is the default amount once it is come.
It is an important thing that we need to communicate, that a section 10 like provision does exist even for Prepacks.
Yes.
And section 4 is very clear. Abhizar, section 4 has made it very clear. Have to have a default.
Have to have a default. No, I agree.
Have to have a default.
So that's clear. Sorry, Radhiji, back to you.
In fact,
back to you. The second question is,
in fact, in the drafting stage, it was given that the pre-stressed defaults should be considered.
Correct.
It has not been taken into the...
Not been taken in. So in the drafting, it was there. You're right. In the initial suggestions.
Yes.
Radhiji, section 8 of the Act says that people can file claims. Under Prepacks, there is no provision to file claims. There is only a provision to verify claims. If somebody does not appear as an operational creditor in the books, what is his remedy?
So he has to go to the court, I think. There's no other way out. So what they have done is to speed up the thing. They have said that let CD itself prepare the list of creditors. And to make it safe, you include even the contingent liabilities, those you have not recorded in your books. But if you fail to mention it in your list, if you fail to include it in your list, then you are in a deep trouble. So in my opinion, that could be a great amount of disincentive for MSME to go for this scheme, because you may not even know that I may have missed out something. Your accountant may have ignored something. You are ultimately relying on your professionals, accounts team, and MSME may not have great finance and accounts team to support you. So if you miss out and God forbidden, the operational creditor is able to establish, or even the financial creditor, then you are in a deep problem. Because then it's
another similar question.
Yes.
And Abhijit here, there is a strict provision that if there is some concealment of the facts by the CD, then the aggrieved party, first of all, can approach the court. And there is a strict penalty provisions also. Imprisonment is also there. Fine is also there.
Absolutely. That's what I was trying to say, that it can be a great amount of disincentive for MSME to go for.
In your experience, Radhiji,
yes,
as Snehal ji said, that there is a lot of avoidance transactions. It's going to be very difficult to build that into the base plan to succeed. A lot of people have commented that, with avoidance transactions, prepacks may be a non-starter. Similarly, you are saying that creditors could have been missed out because they don't have great accounts and finance departments. So that is another. Now tell me, all these things, will they have an implication on the original base plan submitted? And does the corporate debtor have to right to revise, or will the RP have the ability to revise the base plan for any avoidance or claims, etc., that could then come up?
I'm not the actually right person to answer that. It's a technical question.
It certainly is.
I would assume that, see, my understanding is that even in CIRP, these avoidance transactions are to be decided by NCLT, and NCLT takes its own good sweet time. So how do we see that the RP will have the power to revise the base plan or do anything? But I would like to point out one thing. See, let us compare plain restructuring versus this prepack. I have the choice. I have the choice to go to the lender. In any case, I need lender's approval before I can even initiate for the restructuring plan. So even in that case, the lenders most likely will insist on forensic audit. So in my opinion, the forensic audit and the transaction audit scope is almost same. So the MSME for CD knows that at some point of time, उसके कपड़े तो खुलने हैं, उसने यदि कोई पाप किया है तो वो तो दिखने ही वाला है. So he has to take that risk. In my opinion, that's not going to be such a great disincentive. But I have got other point. I'm just deviating a little bit.
Sir, I'll just question you on this point.
Yes.
Then why not I do an OTS and close it?
Absolutely. I was about to say that instead of going for this jhamela of prepack and getting myself subjected to another person and another regulator and binding myself so much to COC, why can't I just go for restructuring? What is the incentive? Because if I have to take 66% approval, maybe I will go for section 230. Why should I need this thing?
But 230 requires 75, sir. But yeah.
So for 9%, I will not perhaps like to take the trouble. But I think the point is that if my operational creditors, and that is more of government liabilities, is used, and I want that those are waived, then that is the prepack is the option. The second use of prepack could be when you are going for change of management or sale of stake. The new management may like prepack as a platform so that he gets it on a clean slate.
Understood, guys. Very useful.
Just one issue, one more point I want to add quickly because we're on time now. Actually, it is going to institutionalize the whole process. Let me tell you, the bankers and the FIs are not very comfortable to do OTS. This whole prepack mechanism actually institutionalizes the whole process. It is extremely transparent. And then over a period of time, people will get into the groove. You may see initially that people will have deterrence to go for prepack. But over a period of 1 year or so, you will see that people will actually start putting their books in records and in place, etc., etc. And we'll see more of people coming into prepack.
Abhizer, if I can add one small thing, this prepack over a period will be many times will be used for restructuring. As I have been associated with MSME for a long, I have been a part of MSME IPOs. So a company which intends to clear out their past and want to go for a growth model probably may go for this prepack model, clean their books, work out the structure and move. So this structuring on the MSME will start in a big way through prepacks and the growth model can come. But it will take time till the MSME understands the importance of maintaining the discipline in their financial books of accounts. And then it will sail through in a nice way.
I would agree. So clearly, first of all, your banks have to do OTSs, I agree. First of all, I must say that what this will remain is going to be at a GM level. I don't think a lot of the proposals of MSMEs reach HO. So as long as they have an externally viable process, which is a well-defined external process, they will go for it. Until now, they did not have it, and hence they preferred. If they have a choice between a OTS and a prepack, I'll be very sure that they would rather follow a process and go for a prepack.
Abhizair, what will happen in realistic position or practically is a trial run would be done, because the timelines are so short that if you have not done the trial run, the pre-process run before the prepack is initiated, then it will be very difficult to manage. So specifically timelines for the bankers, 48 hours voting. In CRP, we have seen that they want 5 days, 6 days. They don't want less than that. So how in 48 hours?
That is because, sir, approvals have to go to HO.
So whatever may, sir,
it is a branch level GM, is easier.
Approval from GM level also in the small, because I have never tried my hands on large cases. I have been handling MSME only. So in that also they have been insist, because they have made standard, whether it is a big case or small case, 5 days we require for approval. Now this 48 hours approval from them is going to be challenged. Same way, all timelines, except IP, we are now accustomed to timelines. Whatever you tell, 2 days, 2 days, 3 days, 3 days. We dance on the exactly timelines what has been given in the rule book. But other people timelines, like if there is a Section 7 application filed, within 14 days, our application, if the pre-PR to be adhered, I don't think that will come in play very fine, nicely. Judiciary to take this application, come out with that timelines is going to be a challenge. So there will be various challenges coming on the other things, except RPs. I assure all RPs now have learned how to do in 180 days, and now they will learn how to complete this in 120 days also.
Okay, sir. Yeah, a question to Yogeshji, because he always he's passionate about Section 11. So I have to ask him this question. Sir, do you think this Section 11 requirement, which is of 14 days, filing, etc., will be adhered to? One? And secondly, a question, so I'll ask you this question. So what do you think about this? What do you think of Section 11 itself?
See, as has been given by Pakol in the presentation, that if you are filing an application under PPIRP, okay, then it will have the priority over the application under Section 7. If you have filed an application now and there is an existing application under Section 7, 9, 10, as on the date of the ordinance, then PPIRP will not be able to come up. No application can be filed under PPIRP. If the application is pending under Section 7, 9, 10 for more than 14 days and the PPIRP application has been made after 14 days of the earlier application under Section 7, 9, 10, then no application, the priority will be with the 7, 9, 10 applications, not for the PPIRP applications.
Yes.
It has been filed within 14 days of the 7, 9, 10 applications, then the priority again will be given to the PPIRP application. So there was earlier some confusion with respect to the limits, which I think that there is no confusion and there is no, upper cap on the default amount. So even if the default amount is more than 1 crore rupees, the application can be filed under PPIRP as well as under the CIRP.
Correct. Now, I just want, I'll have to conclude this in the interest of time because we are past 1 o'clock. I just want to leave one thought with everybody. Yes, we can all crib that it's only 90 days and it's not enough. Prepacks internationally happen in 2 days. I agree we can't do it in 2 days because we have a lot more processes to follow. And that is why we can't do it in 90 days. Point accepted. But the reality is that if we are able to plan this well and do a lot of the work before initiation, work with the banks could appoint an RP any which way before filing also with the courts, before your 90-day ticker starts. If you are in agreement, and if it's an MSME, it is quite possible. If you are in agreement with all your avoidance transactions, if your avoidance transactions are well built in whichever fashion into the base plan, if it is agreed with the banks that we are going to approve base plans, I think the process can run smoother than you think.
Definitely.
This is not a program where we have to run Swiss auctions or e-auctions. It should not reach that stage. Then you might as well go for CIRP. You are not meant for PIRP. In prepacks, we should avoid and get the base plan in such a way that you actually avoid any kind of auction. Because the reality is that for MSMEs, there are no bidders. And ideally, we should be able to work, it's like a resolution with the court's consent. And I'll tell you what is the biggest advantage is 32A. When people want to come into this kind of a company and acquire it, or if the promoter himself wants to get another investor or do it with his own company, he can get a 32A protection. And using that 32A protection, he can actually get a fresh start. Otherwise, there is too many legacy issues. You discuss with the banks, how do you want to deal with avoidance transactions? Come up front with them that these are the avoidance transactions. Our problem is two things with MSME, from whatever little I know. One is the ability to come into the formal system. And increasingly, PIRP should ensure that MSMEs come into the formal system. And by the way, this is happening by the day, with GST happening and everything else happening. More and more transactions are coming on books than remaining off books. So that formalization will come in. And the past sins can be got rid of for the issues. The second and the more important thing is the fact that there has to be a level of transparency upfront with the lenders and that much of confidence built into people that we'll be able to deal with it. If these two things do not happen, then I think the MSME does not deserve a CIRP or PIRP. But if they actually manage to close that loop and that mindset change, that's why I said PIRP is more about mindset change, less about rules. If you're able to change the mindset of your people, and the RPs here are best suited to do that, because you are closest to your clients. And of course, with your fellow RPs, you can work out who will be the RP and who will be the advisor. And I'm sure that issue can also be resolved amicably. So with that, I would like, so the other important thing is we are planning to do an FAQ, and we are planning to do a representation through the IICA. And I would appreciate if all your queries, whatever you have raised, have been taken into account. But if you can please put on your queries to Prakul, and Prakul, I'll appreciate if you can please put your ID onto the main chat, where people can put up the queries to them. We will spend time analyzing it, Prakul, into what goes into an FAQ and what goes into a representation. And this panel here will then meet once again to discuss those answers, refine them, and then take appropriate action as is deemed fit. And we'll try and do it under IICA. Of course, it's subject to the approval from the authorities. If not, we will do it as any of the IP associations. But let us put forth our problems in terms of what we believe are right. It's a no names thing, so that we do it through an institution. That was the reason to do it through an institution. If we can get these queries together, I think it will be a lot more helpful. We are planning to do further sessions with bankers and with MSME clients itself. And we'll plan that as phase 2 and phase 3. But it was important to first get the IPs buy-ins. So with that, apologies, there are 68 questions that are there unanswered. But we will aim to do it as part of the FAQ or Q&A or whatever representations we need to make. I will hand it to Mr. Navandar to please do the closing. Thank you.
Navandar ji, unmute kariye.
I will just take 2 minutes. I will not stand between the lunch. First of all, thanks to Dr. Niti Madam for organizing the entire program. Then thanks to Mr. Abhizir Diwanji for laying down the program and structure of the program. No words for Mr. Prakul. His plan, read as a presentation as a plan, has been approved, unopposed, not only by the COC but AA also, and so many appreciation with a lot of high ticket size that nobody can compete with him. And lastly, the
Thank you, sir.
Vote of thanks for the all panelists for taking all the question answers and further agreeing to have a discussion on the question answer. And all the attendee, it was the maximum attendance was around 380, 390 on a Sunday morning. Taking out time for the session in such a large number is really appreciable. Thanks everyone.
And that too having 4 presentations in the last 2 days on Prepacks.
Yes.
Niti, why don't we just take a picture of this whole screen so that it can go to our website?
And Prakul, are you going to load the presentation on virtual law or on IICA? We like at IICA, please.
So, so it will be on IICA website. I have written the website link in the chat box. And also I assure all of you that internally we will discuss with our esteemed panelists, and we will be taking all these questions to the ministry. I just had a word with my my DG, Dr. Sameer Sharma sir, and he has ensured that whatever questions have remained unanswered, for which we don't have an answer, we will take it forward with the right stakeholder. I'd also, sir, like to inform all the members here present that under the leadership of Abhizer sir and Mamta ma'am and other AC members, we are also starting with the continuous education program for the existing IPs. We have done one in the past on ethics, which was very well attended. The other is on how to protect IPs from the experience of what our dear friend Anuj Jain sir went through. We are taking this, cause forward and discussing that. MSME is again a new venture, but IIC is now going to deep dive into continuous education program for the IPs. And for that, I think I'll need guidance and support of all of you here. And we will keep updating you on this. You can follow us on Twitter, IICA officials on Twitter or LinkedIn. And of course, you can follow Abhizer sir also and Mamta ma'am's account. And we will be, continuously updating you on that. Praveen sir.
Any of the hot topics that you really need similar presentations on, we'll be glad to do.
Yeah.
So just let us know. Somebody from IICA will take it up, research it, and we'll do it a similar way.
Absolutely. Niti, we'll just discuss that. I think let's close it.
Yes, yes.
Let's ask Prakul if Prakul can help us. Prakul, if you can just take a snap of.
I actually did, ma'am. I'll take one more. Maybe for all are looking at the camera. Abhijar sir is not looking onto the camera.
Abhijar.
We'll just take a picture, sir. Yeah.
Praveen sir, you could just sit a little. Yeah. Right. Thank you.
Yeah, ma'am. Done.
Thank you. Thank you. Niti, thanks for this.
Thank you, everyone. Thank you.
Excellent work. And thank you to all the panelists. Abhijar, you lead from the front. So proud of this. Thank you.
Thank you.
Thanks.
Thank you.
Thank you.